After almost 20 years, a pregnant woman was raped, and in fact, 14 people were almost killed. The convicts who were basically sentenced in this particular case have walked free after a remission order. I have with me Advocate Shobha Gupta, who's represented the victim and knows this case for a very long time. Ma'am, welcome to CNN News 18's StreamYard. First of all, ma'am, first question to you: how do you see this order that is coming from the Gujarat government, and what is the corrective measure, if at all, required in this particular case?
Do I need to define this order now? Like it's horrendous. Like, how would you pass? Why would you pass this order? Unless you close your eyes on the facts of the case, uh, which were writ large to each one of us as memory. You say Bilkis's case, and things are so open to you. Why was the need of getting into this order without getting into facts or completely ignoring everything? I refuse to accept that if you actually see the facts of the case, any person having even this much of you know the sense of rightness in you can do that, can proceed with this order. No justification for this order.
Ma'am, another question is that it has somehow become a legality versus ethic debate, and a very very important question is that whether this whether there have been previous precedents where such convicts have been remitted or released, and what has happened after that, whether there has been a challenge to the Supreme Court of such orders. If you could take our viewers through that, because you've been a lawyer, the top court, for a very long time, and you know the law any day better than us.
No, but I refuse to accept that what you are saying, that it is a debate of legality versus ethics. I'm so sorry. Nobody, when we are objecting to this order, or anybody, I believe, when they are talking about that order is bad, we are going on ethics only. That's the legal requirement. The 1992 policy assume for a moment that state of Gujarat is the correct state to go for it, which I refuse to accept that also. That's something we would deal in court. But assume for a moment it was state of Gujarat and its policy which had to be looked into, and only 1992 policy had to be looked into. Then 14 years is only opening gate. It's only that once you complete 14 years, you could apply. Before that, they could not even have applied. They were not entitled to apply. That doesn't mean that is the maximum punishment had to undergone. That was a minimum period to have undergone, then only you could have applied to. But in remissions do not comes like a cakewalk. After all, remission means what? Some executive are sitting to deal with a judicial order. Judicially, a view has been taken against a person, so to say he has to undergone this much. Here, four courts, three courts: trial court, high court, Supreme Court. Then, and matter of this nature. And when we say matter of this nature, we are not referring to ethics. It is again the legal requirement to look into the nature of crime, the impact of the crime, whether the impact was on individual alone or it had caused an impact on society also. What was the nature of crime? How gross it was? Would it be appropriate for this kind of criminals to allow to come back to society? Do they deserve that clemency? These are the legal factors. These are legal requirement, the factors to be looked into. Nothing on ethics. Ethics,
Ma'am,
we are not
another
even.
another important question, and as we are speaking about this, Have there been incidents in past where such remissions have been done and there have been judicial challenge to it? And how has things been dealt in past with other cases of similar crimes, whether we call of rape or we call of serious murders that have happened in the country, or maybe internationally as well? Are there any past precedents as well?
No, there may be stray cases where, single murder had been caused. You have seen cases where we have seen people being hanged for murder, right? We had
Yes.
that Dhananjay's case of West Bengal. We have recently seen in Nirbhaya's case. So
Yes.
we do have examples where they had to be hanged. This was a clear case of the highest punishment to be given, that is the death penalty. The law requires that, as per law, this case was punishable, this offense was punishable for death penalty. So there was already a clemency come to their way, that they were granted only life imprisonment. But in the cases of this nature, if you are asking me any such example, I'm sorry, I have no such recollection where the crime as gruesome as this was. In fact, I have not even been able to say, draw a parallel of such nature of crime. Have you heard Nirbhaya's mother saying that it was much gruesome crime than? So though we are not supposed to draw parallel between two crime, but this is her mother. Nirbhaya's mother is saying this case was much more gruesome than Nirbhaya's case, which so many may disagree. But can you imagine a, a group of people running helter skelter to save their lives? They were, for last 3 days, they were shifting places to places just to save themselves. It appears that this crowd, or these accused, were following them, chasing them. So much so that far away from the village, they came up to this forest, committed this horrendous crime where you are murdering 14 person. Before murdering, the women were gang raped, multiple. This lady saw her mother, sisters being gang raped and killed. This lady saw her other relatives, 14 of them. So many news channels are saying 777, but that's 14 relatives she lost, including her 2.5 years old child. Your child being smashed in front of you. She herself was pregnant and suffered all that atrocities. She wakes up amongst the dead bodies around in dead of the night. Collect the courage to go up, take clothes from any of the dead body, wear them up, go wait for someone to come help, go to a village, get some clothes from there. Like, it must be, I keep saying, but for a divine intervention, she could not have survived. In crime of this nature, if somebody has gone, to my recollection, I do not see any parallel that any other crime of this nature and clemency had been shown. In fact, in all such cases, death penalty would have been granted and people would have been hanged. We have seen in
It was
single murder cases, death penalty is granted and people hanged.
a rarest of the rare case in its nature. And
Extreme. If there is any other definition of rarest to rarest, it is like 10 times rarest to rarest kind of case.
ma'am, another question to you. As we are speaking today, two petitions were mentioned. One by Mr. Kapil Sibal, it mentioned it, and another by Mr. Shadan Farasat, who've challenged this particular order of remission and asking for immediate intervention of the topmost court of the country, the Supreme Court, bench head by CJ. And V. Ramana has also said that they will look into it and would definitely disc the matter. How do you see this development, and do you think that something or the other would happen in this particular case at least?
Something and the other means what?
Some kind of an order would come in from the Supreme Court, because the matter would definitely be heard because the bench has already asked for it, have already accepted the mentioning somehow.
See, we shall have to wait for the matters to be listed. We do not know the nature of petitions, whether these are PIL or they have filed petitions with permission, application for
These
permission.
are both,
There can be
both the
either of
matters are both the matters are
both of
PILs.
them are PIL. Okay, so they then are reaching to court as the society, as a concerned society, and let's wait what happens to these petitions. I'm hoping some good order should come, because it is something which is shaking up everybody's conscience so badly.
One another question before we come to the end of it is like, what change do you think that there should be in the remission policy in the law, so that such things, such criminals do not get released, or such people who have committed such horrendous crimes, in fact of rarest of rare natures, should not be released, or some kind of a defensive mechanism should be there, or what should be there? Do you think a change in the law that is required?
No, no change is required. This, it is only the persons who are given this responsibility to look into. Supreme Court only said go and apply there, and they need to look into within 2 months' time. That never meant that grant them remission. Had these committee members applied their brains upon the facts of the case and the legal mandate, the mandate of law, your central government policy says the you can't grant remission to a rape convict, a gang rape convict, murder convict. You have judgments after judgments from 2005 onwards, where they define that life imprisonment means till last of your breath. They are judgments after judgments which say that you have these are the factors to be looked into before granting the remission. In fact, there are few judgments which says we are coming across remission orders like this, which are very clear that the committee is not applying their mind. So this
So
had
there is a need of sensitization of these officers or people who are there. Is that
you
what
know
you're trying to say?
the simple thing is apply your mind. Look into the file. We have heard one of the committee members saying that we don't even know whether the crime was committed or not, or they belong to a particular community. Now, if you don't know even crime is committed or not, that means you have not gone through the file where the conviction has been upheld by three courts. If no crime was committed, then why you were sitting for a remission? So the point is no sensitization is needed. If you are given a job, if we give cleaner a job to clean a room, he is supposed to clean it properly. If a committee is constituted not 1 or 2 persons but 10 persons, they were supposed to read the file. What is the order of conviction, judgment of conviction? What are the factors? What crime they have committed? Now, if one of the committee members says we do not know if the crime is committed or not, then certainly they did not apply their mind. They have not read the file. Had they read the file, had they applied their mind, have they applied their mind to the necessary factors to be looked into, this remission order could not have come. So you don't need any change. You talk change today. Tomorrow they would come and say, now you have brought in change, it would apply prospectively. This is a dangerous theory you are talking of. The moment you talk of a change, that means henceforth,
Thank you so much,
existing
Shobha Gupta for, yeah.
policy is good enough. They had to do their job properly, which they miserably failed,
And
and brought a shame
the
to nation. Brought a shame to nation. Internationally, we are being looked down. We are being looked down so badly.
ma'am, last question before I let you go is, whether you would also be filing something in the top court, or is would there be something or some sort from the end of the victim that would be filed in the top court against this order?
See, neither me as a person, nor we who are assisting Bilkis, nor Bilkis herself can allow ourselves to live with this order, this remission order. You can't live with this order. We genuinely were waiting. Bilkis is waiting for the major stakeholders, that is state, be it state of Gujarat or central government or CBI, to put up a challenge, or to ask for recall or for cancellation, whatever. But if none of them pick up anything and it this order continues, then certainly she would be challenging it.
Thank
She
you
would
so
be
much, Gupta
sooner.
ji, for joining us. Thank you so much, Shobha Gupta ji, for joining us. It's been a pleasure talking to you and discussing as to whether there can be a change or what can happen in such cases later on. Thank you for watching the newscast with on CNN News 18. News and updates continue on CNN News 18 and news18.com.